I'll see his grave. Drowning in the monotone, no escape today. But I need a haircut, break the static's hold. Losing up its time, it bites the story's toll. Say goodbye to boredom, headlines made of gold. Twist and shake perspectives in a way so bold. They serve it up with humor with a snarky twist. Little bites and moves to fill your daily list.
Hey guys, it's Mo from Mo in the Deep End, and that didn't take long. Looks like an appeal may be on the horizon sooner rather than later for the Delphi case. Odinism, confessions, alleged judicial bias among issues Richard Allen could raise on appeal. Now, could and most likely will. So I know that there's a lot of division in this case, but I do want the people that are very for sure that Richard Allen is guilty to be aware that is a great possibility for an appeal and possibly a retrial in this case. And for those of us who are unsure if, Richard Allen is the one that did this and if they proved this in the state's case because of the secrecy, because of all of the media lockdown, these are possible avenues for appeal, not so much the media lockdown, but all of these different factors. This is a local outlet, so I will be giving you the local perspective and reading this article with you. So let's get into it. Moments before Richard Allen's fate was announced in a packed downtown Delphi courtroom Monday, Special Judge Frances Gull gave a sobering assessment of the case that has haunted the Indiana community for years. Quote, regardless of what the verdict is, she said, people will not be happy, end quote. Possibly the only astute and perceptive thing this heifer has ever said in this case. Sure enough, everyone has retreated to their silos. Outside the courthouse, those that believed Allen was guilty are relieved that justice has been served. And those who believe that Allen has been railroaded while the real killers are at large are angry and in disbelief. Indeed, Allen's supporters seem to already be gearing up for the next phase of the legal fight, a lengthy appeals process. Within hours of the verdict, a website called Justice for Richard Allen began circulating on social media. This isn't over at all, a visibly upset Kathy Allen, Richard Allen's wife, said as she left the courthouse Monday while being accompanied by defense attorneys. Allen was convicted of 2 counts of murder and 2 counts of murder while kidnapping Abigail Abby Williams and Libby German. For Allen's supporters, he was convicted not because of the evidence that the jurors saw, but what they did not get to see. Allen will most certainly appeal, and when he does, Odinism and Gull's decision to not allow his defense team to present jurors' evidence pointing to an occult sacrifice will likely be a key part of it. Also, I want you to remember, and I do believe that this is grounds for appeal, the lack of parity between funding for the state's experts and the defense experts. If you guys remember earlier reporting on this case, the defense basically had to crowdfund a lot of their experts, and most of their experts were not let in this trial. But they did have to crowdfund it because the court said no to a lot of their experts. So the lack of parity between the state's experts being paid, whatever sums they were paid, and the defense having to crowdfund could be a real appealable thing. Allen's defense team aggressively pushed their theory that Odinists, members of a pagan Norse religion hijacked by white nationalists, unalived the girls during a sacrificial ritual in the woods. They put together an explosive 136-page memorandum laying out what they believed to be compelling evidence pointing to Odinism. They argued that the sticks and branches were arranged on the girls' bodies, and a letter was painted on a tree using Libby's blood to resemble Odinist runes and symbols. They put forth names of purported Odinists who they said are viable suspects in the case, including a Logansport man whose son dated Abby and who, the defense alleged, posted cryptic images on social media resembling the crime scene. During a pretrial hearing in August, a former state police detective who investigated the Odinism angle testified that Brad Holder's social media posts were, quote, not a coincidence, end quote. At the same hearing, an expert called by the defense testified that the teen's death were quote-unquote textbook examples of ritualistic murder. But ultimately, none of those were enough to convince Gold that the jurors need to hear about Odinism. She ruled that presenting such evidence would only cause confusion and potentially mislead the jury. In his appeal, Allen could resurrect the issue of judicial bias. That Gold was not a neutral arbiter, but a judge who has shown explicit favoritism to the prosecution. Yes, there are receipts. Quote, that is basically what the defense thought hamstrung them, said Joni Madeira, a Indiana University law professor who's been following the case. They couldn't present the narrative they wanted. There are still gaps that they could not fill, and I think that's going to be a central focus of their appeal. As testimonies began last month, Gull also ruled that the jurors would not see the two widely circulated composite sketches that the police released in 2017 and 2019, siding with Carroll County prosecutor Randall Nicholas McClelland that the artistic renderings were based on witnesses who described a variety of facial features but noted they were not certain of their identifications. The defense attorneys argued that the sketches showed two different men, neither of which resemble Allen and were highly relevant. I think that, or I think the most appealable issue is that his attorneys attempted to bring in the fact that there were other possible suspects in the case, and Judge Gold refused to allow that, said Indianapolis defense attorney Jeffrey Mendez, who's been following the case. The incriminating statements that Allen made while awaiting trial at Westville Correctional Facility and Gull's decision to allow them to be presented to jurors could also be raised on appeal, experts say. The case against Allen relied partially on the dozens of statements he gave in prison, to his therapist, and to many phone calls to his family. The prosecutors presented some of those confessions, including one he made to Dr. Monica Walla, his therapist at Westville. Now, according to Walla's notes of that session with Allen, he said he intended to assault the girls, but he was spooked by a van driving on a private driveway nearby. That vehicle, according to testimony, belonged to Brad Weber, who lived near the trail and who told the jurors he was coming back from work in his white van around 2:30 p.m. on February 13th, 2017, a few minutes after the girls would have been forced off the trail into the woods. That van, McClelland reiterated to jurors during his closing arguments, was the detail that only the unaliver would know. Before Allen's trial, his defense attorneys tried to keep his statements from being presented to jurors, arguing that they were made involuntarily and in the throes of a severe mental health crisis while in solitary confinement. But Gold decided to allow the statements to be presented to jurors, ruling that the conditions of Allen's pretrial detention were, quote, not intended to force confessions, end quote, from him. Sure they weren't. Questions about whether those statements, many of which Allen made while receiving antipsychotic medication, uh, and should they have been admitted into evidence, will most likely be raised on appeal, Tompkins said. Another issue that could be raised is Gold's decision to block a metallurgist from testifying, Tompkins said. Dr. William Tobin's testimony was meant to challenge the state's findings that the bullet cartridge found 6 inches from Abby's feet had been cycled through Richard Allen's Sig Sauer Model P226 .40 caliber handgun. Prosecutors argued while Tobin is a recognized expert in metallurgy, a field that studies metallic elements, he is not a firearms expert and had no training in firearms identification and has never conducted firearms examinations. The unspent round was a single piece of physical evidence connecting Allen to the crime scene, and jurors heard from Indiana State Police firearms examiner, whose analysis concluded that the cartridge was tied to Allen's gun. Now, if you have not been following this case, they had an unspent, just cycled cartridge, and she matched it to a fired bullet. These are apples and oranges. It's a subjective test, and she did not know, a lot of the sort of regulatory things that people have been trying to do to sort of make this from a subjective, somewhat infallible or through the eyes of the technician science to a more science-like, provable, testable, observable thing. Let's see, once you let that forensic evidence in and not allowing a metallurgist to testify becomes an issue. Tompkins said. Allen is scheduled to be sentenced on December 20th. He then has 30 days to file a notice to appeal his conviction and his sentence. His appellate attorneys and the state, which will be represented by the Attorney General's office, will each file lengthy briefings laying out their arguments, and there will likely be a hearing before the Indiana Court of Appeals. The possible outcomes, according to Mendez, the appeal courts find that there was no error at the trial court level, or it finds that there were errors, but they were not significant enough to impact the outcome of the trial. In both cases, Allen's conviction will stand. Allen can then ask the Indiana Supreme Court to review the case. Another possible outcome is that the appeal courts finds that there were several or significant errors in the case that Allen's conviction should be reversed. If this happens, the case will be sent back to Gold's court. McClelland will have to decide whether or not to try Allen again. This means McClelland, as the elected prosecutor, will have to ask Carroll County officials to spend more taxpayer dollars to put Allen back on trial. The Carroll County Council already appropriated a little over $4 million for this case. There's another, albeit remote possibility, a plea deal. If the case is set back to Gold's court, the parties can decide to negotiate a plea deal to avoid yet another costly and controversial trial. That's a theoretical possibility, Tompkins said, but he added, this is a defendant whose defense was, I didn't do this. You don't, as a defense attorney, tell a client who's innocent to go in and plead anyway, end quote. So there you go. There's a little bit more Richard Allen news. I do expect that there will be a lengthy appeal process. I do think it is going to be a general circus, as have most of the things, that have involved this case have become. So I do hope that we finally get some, resolution in this case, an outside look at what Judge Gold did. I don't take my word for it. I've seen lawyers that are confused as to the absolute ridiculousness that happened in this case. I do have a Delphi playlist. It's not as voluminous as some people, but I do have some, and you can kind of see how I've evolved in this and sort of come to my own opinion. No, I did not rely on Andrea Burkhart or Defense Diaries or anyone else when coming to my own opinion on this case. Feel free to, disagree with me respectfully in the comments if you disagree. And I hope that, we can have different perspectives on this and many other cases, but still be cordial, kind, and, not question the morals or intelligence of other people. Keep it kind, keep it respectful in the comments, but, I don't want an echo chamber, so if you disagree, I completely understand. This is a kid case that was monstrous, and everyone wants justice. So I know from that perspective that there are people that are going to disagree. Any hoozle, I'm going to pop off now and make sure that everything is going okay in the house and the cats haven't, started a gang or anything. I'll see you guys later. Bye.